So I congratulate Duke Center and the Stern Kessler Law Firm for bringing us together and allowing examination of this interesting factual and statistical information. It is.
That's only for the webcast. We don't need it for this room.
Right, no, I know.
It strikes me as a little bit ironic that friends in government and academia have focused so much on factual and statistical information, whereas the legislators making the major decisions seem to be much more focused on relative lobbying leverage and special interests and highly funded PR campaigns and lobbying campaigns and so forth. But that doesn't diminish the value and potential contribution of the academics and government officials and others who are focusing on facts and statistics and numbers and analysis. Part of the reason why it's not wasted is that patent reform on Capitol Hill has become a permanent war. So whatever happens this summer on the what I'll call round 2 of patent reform, with AIA being round 1. Round 3 will start not later than the first month of the new Congress, and probably go on from there. And so the work being done by our speakers and others like them has potential to influence future rounds of patent reform, even if its influence on this year's round might be quite limited. The only other thing I want to observe is that I think it would be helpful if everyone focusing on these issues widened their lens a little bit. So, for example, when it is stressed, and it is certainly true, that the decisional phase of an IPR must be concluded within 1 year, and it's greatly to be commended that the Patent Office has met that deadline in every single case, at least so far, and seems committed and at least so far capable of meeting that deadline. But the deadline is a little bit misleading. As Judge Bolick mentioned, there's a 6-month petition period, so we really shouldn't be talking about 1 year. We should really be talking about 18 months. And then there's the inevitable Federal Circuit appeal, so we really shouldn't be talking about 18 months. We should be talking about 36 months or nearly that length, because as a practical matter, if I'm a district judge, I'm very likely to stay the case in front of me indefinitely, indefinitely meaning through the Federal Circuit appeal. So there's the prospect of an IPR becoming a near automatic 3-year timeout in the progress of the district court litigation. Now, of course, this assumes it's filed within the statutory time limit of a year, which isn't difficult to do, and I'm sure that anybody who misses the deadline will have a problem with their malpractice insurer. So I think it will become increasingly common. That is, if I were defending an accused infringer, in almost every case, I would file an IPR. It would take a very unusual set of circumstances to persuade me that I would be better off not filing the IPR. And I think that as district judges hear, even if it's in an impressionistic kind of way, that this proceeding is very potent and lots of patents are invalidated, that's all the more incentive for the district judge to wait, because they're all horrendously overburdened. There's 600 active full-time trial judges and another several hundred part-time senior judges, and every one of them is horrendously overwhelmed. So the incentive for them to grant a stay is very high, and it will keep rising because the Congress, in every successive Congress, declines to provide the additional judgeships that the Judicial Conference has asked for every year for the last 20 years. So the number of judges is way behind the workload needs, and therefore, as filings increase, which tends to be the overall historic trend, the workload mismatch gets worse and worse, so the pressure on every district judge gets more and more uncomfortable, so the incentive to grant stays goes up and keeps going up. So we need to look at the interplay of all these different systems, and both with regard to time frames and outcomes, to see the whole picture and not just a focus on a sort of tunnel vision of, you know, what's happening inside the courthouse or what's happening inside the PTO. And in addition to those important places, what's happening in the investor markets seems to me to be critically important, because for most entities, substantial investments have to be made repeatedly and often in increasing amounts in order to promote further R&D and commercialization of new products, new cures, new solutions, and all the rest. So we have to widen the lens beyond the courthouse, beyond the PTO, beyond even the government, agencies like the International Trade Commission, Food and Drug Administration, Customs Service, and others. We really need to look at the private capital markets and see what the impacts of uncertainty, of delay, of adjudicated outcomes are, because in the final analysis, at least in my opinion, the most important impacts of the entire set of systems, these intersecting systems, is what they're going to do for investment decisions made by money managers. And by money managers, I mean people within corporations. Do I invest from my revenue stream 2% in R&D or 10%? And this is going to turn, of course, on estimates of the likelihood of a good return and how fast it will come in and what the risks are and so forth. And if I'm an outside capital manager, I might be a venture capitalist, but I might also be some giant bank and every kind of institution in between, similar calculus. What's the odds of a good return? How soon will it come in? What are the pitfalls? And what are my alternatives? If I have 100 better alternatives, I'm not going to invest in R&D. I should, because the country needs it, but I won't because my overseers, stockholders or whatever, want me to make money for them, and therefore I have to take the best alternative. So we need to see all these effects if we're going to have a productive discussion as a community on how to have the optimal intellectual property system in this country.
Thank you for those interesting comments. And I really appreciate Scott and Alan being here, and I think giving us some really good, solid information. I wanted to first just congratulate the PTO on the hiring it's done on a lot of the PTAB judges, in that I think all of us, a lot of us in this room, have friends who have become PTAB judges, and we have been uniformly impressed by how what high-quality people are going there. In addition to that, I think we've all been really uniformly impressed, again, by the high quality of decisions coming out of the PTAB and the thoughtfulness and the carefulness. And in all of this discussion, I think there has really not been a criticism with regard to the quality of the work product coming out of there. And I think it's super important to keep that in perspective. I know when the AIA issued in 2011, I thought, holy smokes, the PTO has a year to get this program up and running, and I don't think they can do it, right? And kudos, really, for getting it up and running and having a really high-quality program. And again, I want to push back in the mindset of when AIA passed, there was a widely recognized need, as there still is today, to really address what the problem of low-quality patents, the issue, and that, you know, I'm from Google, plague my industry in particular, but are always bad for innovation, and that always really affect investment decisions. You can talk to a lot of VCs who think about investing in startups, and they are now really concerned about those startups being hit with litigation on what are essentially low-quality patents, and having this mechanism to be able for the agency to essentially check its own work in a very thorough process is essential to a well-functioning patent system. So it's great to see that happening. Scott's statistics were, I think, interesting and important to keep in mind when understanding what's happening before the board and how the program is really working, and they are sometimes not the statistics discussed, but ought to be. Alan's, this is the first time I have seen Alan's work on this, and again, super interesting. I think what he has showed, and I don't want to steal Sean's thunder, Unified's recently showed us a similar point, but that not all patents and litigation are being challenged in IPRs. Far, far from it. And I want to say, is from a company perspective, we do not even come anywhere near challenging every patent that we're sued on in IPRs. We are extremely careful about what patents we choose to put into an IPR proceeding because there are very important safeguards built into the system, or intentionally in the AIA by the Pharma and 21C coalitions that wrote that legislation to prevent harassment of patentees. The estoppel provision is frightening to a defendant. You can't, once you go through IPR, you can't challenge that patent on any issue you could have raised in the proceeding. If you bring a weak challenge and it survives, you're gonna end up settling your litigation because you have now gold-plated that patent, and that's super important. The procedure is super expensive. Maybe we need cheaper lawyers, right? But super expensive and front-loaded. It's cheaper, faster alternative to litigation. It's still $500,000 in a lot of cases. And you're going to be real careful in thinking about, is this the right pathway to go? So that should never, these are good things because it means that strong patents are not being challenged in IPR, and that's a good thing. We don't want patentees to have to go through that. The system is working as intended from that point of view.
So just to build off of Judge Michel's comments and maybe provide a counter perspective to Suzanne's, it's interesting because I think, you know, when the AIA came into effect or passed into law in 2011, I think everybody understood that it would take years to really understand, to fully understand the impact of the new post-grant proceedings. And in fact, I think there's a study requirement after 5 years, something of that nature. So for those of us who had lived through the AIA, you know, we anticipated that there would be this sort of moment of pause where we would allow the system to stabilize, where we would kind of, take a moment to sort of understand how the post-grant proceedings were working. And then, of course, what happened instead was this sort of rush to new legislation. About a year ago, when there was a moment of pause around the new legislation, a number of folks in our coalitions and in other coalitions sat down and sort of talked about, okay, well, if we were to try to craft what we considered to be improvements to the patent system, what would be the focus? And interestingly, post-grant was really becoming a source of concern for a number of major patent owners, major patent stakeholders. And this was really the first time that I had been part of a conversation of, well, how is the post-grant system working post-implementation, post-AIA? And the rhetoric, again, I want to emphasize this was rhetoric because we didn't have the data, but the rhetoric was that in this effort to meet the 1 year's, 18-month deadline, however you want to characterize it, that the PTAB was essentially sacrificing the due process safeguards in order to meet these deadlines. And again, that was perception. And what's so important about the data that PTO is putting forward and that others are putting forward is, does the data match that perception? When you think about what's happening around the Kyle Bass hedge fund scenario, clearly that is feeding off of perception. And that's why it's so dangerous, and that's why the data is so important. Just to push back a little bit on some of Suzanne's comments, we don't know, candidly, whether all the patents that are being put into post-grant are weak, low-quality patents. We don't have that data yet. And of course, the concern that we're hearing now from the bio community and the pharma community is that that's not the reality. That it's just the mere fact of challenging a patent is now creates such a cloud over that patent's survival, if you will, which may have nothing to do with the strength of the patent. It's just purely this perception that, once you get thrown into post-grant, your chances of survival are minimal. But again, it really is important that we have the data to push back on the perception. And of course, that's true with respect to litigation reform as well. And what we've seen happen in the last year or so is, a lot of really good litigation data coming forward to push back on some of the rhetoric around litigation abuse. I think it's equally important that we have that data to push back on the rhetoric and perception around what's happening in the post-grant system. But of course, it's also important for PTO to be thinking internally, are we in this effort to meet the deadline that's been imposed by Congress, and of course, there's an onus to meet that deadline. Is appropriate process deference, what have you, being afforded to the rights of patent owners? And there's a lot of concern that there is this sort of asymmetry in terms of the ability of a patent owner to put forward evidence, to amend claims, and all of those issues are being considered by PTAB and are now being considered before Congress. What's happening in the legislative arena is that, of course, because suddenly post-grant is now the focal point of concern, the focal point of the negotiations, you have this kind of mad scramble to fix, if you will, post-grant within the committee process. I think what's unfortunate is that negotiation, if you will, is taking place among a relatively small handful of players. And so, and we've seen this dynamic before with patent legislation, but, from our perspective, these post-grant proceedings are so important to our patent system that, I think taking some time, having some transparency around the conversations that are taking place in Congress, making sure that any kind of legislative fixes, are in fact supported by the data, matching to the problem, if there is a problem that needs to be solved, is critically important. So I worry a bit that we're now seeing the same kind of, rush to judgment around post-grant that we saw around litigation over the past couple of years. Just to build on another comment that Judge Michel made about the kind of almost this sort of knee-jerk automatic stay once a patent is in litigation, that it will automatically go in. If it is challenged through IPR, you will see this almost automatic stay in the judicial system. That was certainly a fear that we had during the AIA negotiations, and at the time the concern was, well, once you got thrown into inter-parties re-exam, you were stuck there potentially for years. Now that concern's been addressed with the deadline, but you have this different concern that once you're thrown into inter-parties review, you are in a system that's significantly different in terms of your rights, the presumption of validity that you would normally enjoy in a court. And so, again, what does that do in terms of the chances of survival of your patent? The other point I'll make, just in terms of the interplay between what's happening in post-grant and in the legislative arena, one thing that came to mind is Judge Michel was talking about the stay issue, is you now have a piece of legislation, arguably a different piece of legislation, but it has that same stay effect that's being considered by Congress, so-called customer suit stay. Well, if you think about the dynamic for a patent owner, okay, so you can't sue the so-called customer, you're forced to sue the so-called manufacturer. Well, what if that manufacturer throws you into inter-parties? Then the court has to, has this sort of onus or impetus to stay the litigation against the manufacturer as well. I mean, again, all of these dynamics create potentially a really problematic scenario for patent owners who are attempting to enforce their rights. So, again, I think all the more important, it's critically important that each of us be thinking about how does what's happening in the USPTO, how does that interplay with what's happening through some of these litigation reforms in Congress? What is the ultimate impact on the enforceability and value of patent rights as a result? So I'll stop there.
David, did you want to make a comment?
I'm happy to say something. We're a little bit behind schedule.
We're a little bit behind schedule, so perhaps we could just have a comment or two from the audience. If there's anyone who wants to make a comment, we have mics available. Or we could go on with our next presenter, and we'll have 20 minutes then subsequently to...
Well, I'll make one comment.
Okay.
There's nothing.
Yeah.
So I agree with some of the stuff that's being said, some is not. I certainly agree that there's a need for data, and I also think that right now is not really the time to be doing the patent reform stuff that's kind of going on, because I don't think there's been enough time for all this stuff to play out and really kind of know what's going on yet. But, you know, we are where we are. I'll take it as somebody that oversees a lot of patent litigation and sees a lot of claims come in, you know, pre-litigation. I'll take issue a little bit with some of this stuff. And again, it's just sort of based, I think, really on data in addition to my personal experience. But, you know, I think there was an assertion that, you know, in pretty much 100% of the cases, you get a stay, right, anytime an IPR is filed. That's just not true. And it's particularly not true, I think, in the jurisdictions where you have the vast number of patent cases. So East Texas almost never grants. District of Delaware, it depends on the judge you get, but most of them are not inclined to do it. So I'll just leave it at that. The 1 year being, you know, is not difficult to meet. I find it very difficult to meet. And one of the reasons is if I'm going to file an IPR, right, I really need to know what the case is about, right? I need to know exactly what products are at issue. I need to know what claims are being asserted and the theories behind them. And then so that I can then say, okay, is this a non-infringement case, right? Am I going to be trying a non-infringement case? Or is this an invalidity case, right? I mean, do I not really have a strong non-infringement position? This case is really an invalidity case. Or do I have both available to me, right? Because if it's an invalidity case, throwing it all into an IPR is a very dangerous thing to do, right, because of the estoppel provision. And as a result, I mean, most people, there are a lot of people, I think, that have just run rampant into the IPR without really thinking about it. I think there are a lot of not sophisticated litigants probably listening to outside lawyers telling them this is cheaper and you're going to get a stay. But it really hasn't played out, and I think you're going to probably see a lot of people very unhappy that they did it. Because I also don't think the statistics bear out that, you know, the PTAB is a death squad for patents. And so, and then, you know, I think as a practical, and I guess as an example, I'll just give you, I mean, again, a lot of patent litigation, right? I've seen a lot of claims. Comcast has not filed a single IPR yet. And it's because of the fulsome estoppel provision and the difficulties in litigation at the 1 year point, knowing and it's really not at the 1 year point. I mean, it takes time to prepare these petitions and stuff. I mean, it's like at the 9 month point, you really need to know everything, right? After you've been served with a complaint. And litigations in most places just don't go that fast, right? So it's a difficult decision to make. And, you know, my understanding is that when the AIA was kind of enacted, that people thought IPRs wouldn't be used very much because of this estoppel provision. You know, I'm not quite sure why it ended up getting much, but I mean, that estoppel provision, you know, terrifies me. So as a result, I'm very reluctant to do it. So I think the other thing I'd make is about VCs, you know, being concerned about litigation against their companies and whatever. I think they're concerned about that. I think they're far more concerned about startup type companies not being able to get good patents on their tech, because without patents, they're virtually, you know, almost worthless. So a lot of them are coming out against the patent reform kind of stuff. So anyway, I'll just leave it at that.
And then we can go.
When we were in the legislative process on the AIA and talking about post-grant, the real focus at the time was on the recommendation coming out of the National Academy study, which said that there should be basically an opposition system put in place to challenge patents shortly after they issue, before investments made, before commitments are made, before licenses issue, so you can make sure that the quality is as high as it could be, while at the same time not doing too much damage to commercial interests that it might have developed around it. So we have the PGR system, and that's the piece that has not kicked in yet, really, very much, and probably needs some discussion. And certainly we'll need a lot of data around it. The IPR system, most people thought, was basically just going to be re-examination moved over from the central re-examination unit over to the PTAB. Given that in re-exam, roughly 20 or 30% of all claims were canceled, certainly that number has gone up in that move. But back to on PGR, I'm curious. Those patents have started to issue, so I would wonder if companies now have not started to plan for that. Do they have systems in place, budgets in place? Are they reviewing publications in the appropriate art units, particularly in the high-tech area, because this was primarily driven by high-tech companies wanting to be able to do this. Suzanne, do you have a budget and a plan? Do you review publications as they issue to file PGRs?
I'm going to challenge the premise of that question that Tech wanted PGR. Tech said from the beginning, look, 50,000 patents issue a year that could possibly be asserted. Google doesn't have the money to monitor and the capability to monitor that quantity of patents and decide what to file a PGR on. So that's why IPR is important. You got to wait. You got to wait till you're sued, unfortunately.
Can I make one comment on that? I agree with. I mean, I don't know about the premise or not or whatever, but being monitoring patents coming out of the tens of thousands of patents coming out that could be interpreted in who knows how many ways. That's just not something that most companies are going to be able or willing or want to do. And on the last, in terms of wanting, I made the comment last night. I think this is another thing where this process is probably completely undermined by our willfulness case law. I think the willfulness case law has willfulness case law undermines that process. It undermines the whole sort of thinking behind patents in general. Like, no one looks at patents until they're expired unless they are forced to. So, because of fear of the willfulness exposure,
Hi, this is Kevin Jekyll from Unified Patents. I just want to make a quick comment about re-examination, the previous system, and now inter-parties review. The statistics, I think, are actually rather consistent. When you look at the cases in inter-parties re-exam, the PTO's own statistics said that 60% of all the cases had 0 claims survive. Original claims survived. There was an amendment process, but none of the original claims actually survived, 60%. And then there was another series of cases between, 60% up to about 90%, where some of the original claims survived, and some were amended, and some were found unpatentable. And then about 10% or so, roughly, were actually found patentable by the USPTO, where all of the claims survived. I actually think that's relatively close to what we're currently seeing now. And so I think there's a lot of numbers thrown around, and again, I think that statistics are important, and I think we're pretty accurate as we transition from an old system to a new system.
Well,